All right, welcome everyone. Today we're going deep on a Supreme Court case that had some pretty big ripples. It's Parker Drilling Management Services v. Newton.
Yeah, this one really got into the weeds of, well, where exactly state power ends and federal power begins.
Exactly. It all goes down to this. Do California's wage and hour laws have any say over workers out on the Outer Continental Shelf? Or does federal law, like the Fair Labor Standards Act, completely take over?
It's a fascinating question, especially when you think about all the work that happens out there, oil rigs, you name it.
So no more suspense, let's get right to it. What did the court decide?
The Supreme Court sided with Parker Drilling Management Services. They basically said California's wage and hour laws don't apply on the Outer Continental Shelf, and that they actually clash with the FLSA, the federal one.
So a win for federal authority in this case. But I'm sure it wasn't a simple yes or no answer.
Yeah.
What were the main arguments that each side brought to the table?
Oh, absolutely. It gets pretty nuanced. Starting with Parker Drilling, their main point was that the Outer Continental Shelf, the OCS, is essentially a federal zone. Federal law is the top dog out there.
Makes sense. It's not like it's just regular California coastline.
Right. And they leaned hard on the Outer Continental Shelf Lands Act, OCSLA for short. That act, they argued, doesn't treat the OCS the same as mainland California. And to really hammer it home, they pointed out this big difference in how sleeping time is calculated. California's laws and the FLSA have completely different ways of doing it if an employee sleeps on the employer's premises.
So a concrete example of how the two laws clash.
Exactly. It creates a direct conflict. And Parker Drilling was basically saying, look, Congress knows how to carve out space for state laws in federal areas. They use these things kind of savings clauses when they want to. But OCSLA doesn't have one that covers wage and hour laws. Not in the way the Ninth Circuit was trying to read it anyway.
So they were saying if Congress wanted California's laws to apply out there, they would have said so directly.
That's the gist. They even brought up the Assimilated Crimes Act as an example. That's where federal law borrows state criminal laws, but only to fill gaps in federal law, not to replace it completely.
Interesting. So Parker Drilling's argument was built on this foundation. OCS equals federal zone, FLSA already covers this stuff. No need for California to step in unless there was a specific gap.
You got it. And they didn't stop there. They also challenged the idea that the Secretary of the Interior has this broad power to preempt state law on the OCS regarding wages and hours.
Oh, right. That was a whole other layer to this case. What was their take on the Secretary's role?
They argued that the Secretary's power under OCSLA is more about things like leasing out those offshore areas and managing resources, not so much about diving into the nitty-gritty of labor laws.
Okay, so that's Parker Drilling's side.
Right.
Federal law, first and foremost. But what about Brian Newton? What was their main argument for applying California's laws?
Well, Newton's stance was that state law should still apply on the OCS as long as it doesn't completely contradict federal law, as long as it's applicable and not inconsistent, as they put it.
Makes sense.
Yeah.
No one's arguing California can just make up entirely new rules out there.
Right. Newton's real strategy was to work within the existing system of federal labor law. They put a lot of weight on that savings clause in the FLSA. Their point was the FLSA is actually set up to allow states to add extra protection for workers, especially when state laws are more generous.
So they were saying just because California's laws give workers more benefits, that doesn't mean they automatically clash with the FLSA.
That's it. They even pointed to a case called Powell. In that one, a higher federal minimum wage actually applied because of a savings clause in another federal law. So they argued it's totally possible to have these layers of protection where federal law sets the floor and states can build on top of that.
So a more cooperative vision of federal and state law, with state law acting as a kind of safety net, did they address those direct conflicts like we talked about with sleeping time calculations?
Absolutely. They argued that, yeah, there are differences, but they're not always deal breakers. Look, this dispute wasn't only about the minimum wage number itself. It was about a lot of stuff that California law does differently. Like, how's a work week actually defined out there? How are things like sleep time and meal breaks handled?
Those are all important pieces of the puzzle.
For sure. And Newton's side was saying, where the FLSA doesn't give specific instructions, a state law that's more generous to workers doesn't automatically mean it's inconsistent. They claimed it's just building on what the FLSA already allows. They even pointed to some guidance from the Department of Labor saying that when the FLSA is silent, more generous state standards should be the rule.
Interesting. So they were saying it's not like these are two totally different worlds that businesses can't possibly navigate.
Yeah. And to make their case even stronger, they brought up another Supreme Court case, Guerra. In that one, the court decided that California's pregnancy disability leave law, which is more protective than federal law, wasn't actually in conflict with it.
Ah, using precedent to show the court has upheld this kind of thing before. Clever.
It's a classic legal move. And beyond the legal arguments, they also made some really practical points.
Right. They brought in the human element of all this.
They did. They emphasized how closely connected California is to the OCS. Like, a lot of the workers on those platforms come from California. Their lawyers are often based there, and they're familiar with California's laws. So from their perspective, it just makes sense for California's rules to apply. It makes things predictable.
I can see that, so especially if you're a worker constantly moving between rigs in state waters and the OCS. Different rules everywhere would be a headache.
Exactly. And speaking of different rules, remember how Parker Drilling downplayed the Secretary of the Interior's authority?
Yeah, they said it wasn't about labor law.
Well, Newton had a different view. They argued that under OCSLA, Section 1334A specifically, the Secretary actually does have broad power to make rules to carry out the act, and that this power could definitely be used to handle conflicts with state law, even on labor stuff. They pointed to things like the EPA, which has agreements to use some of California's air emission standards on the OCS.
So Newton's argument was the Secretary could step in and say, California law applies here if they wanted to.
Pretty much. And the practical arguments about the workforce and all that really rounded out their position.
So we've got Parker Drilling, federal law is king, and Newton, there's room for state law, especially when it's protecting workers, and the Secretary could even back that up. But wait, we had another player in this game.
Oh, yeah. Don't forget about the United States government. They jumped in as Amicus Curiae supporting Parker Drilling.
Right. Amicus briefs are always interesting. What did the government emphasize?
They really doubled down on the whole federal supremacy thing.
Right.
They were adamant that the continental shelf is primarily under federal control. And they argued that Section 1333 of OCSLA was meant to create a single body of federal law for the OCS. State law only gets borrowed to fill very specific gaps in federal law. They were really strict about that.
So very much on the same page as Parker Drilling. Federal law, federal law, federal law.
Exactly. They said applying California law would basically be like transplanting a chunk of California's legal system onto the OCS. And they thought that went against the whole point of OCSLA. They also brought up this practical problem. Imagine federal agencies having to figure out and then enforce California's administrative law. It could get messy fast.
Makes sense. A whole new layer of bureaucracy. And remember, this was all about labor law. What else did the government bring up on that front?
They pointed out that federal law already covers a ton of these wage and hour issues. The Department of Labor has all sorts of regulations under the FLSA. So they were like, why do we even need California's laws here? The feds have got this. Plus, they thought it would be super weird if incorporating state law led to different minimum wages on the OCS depending on which state you are next to. It could create chaos. Federal law already sets a national minimum wage, so why complicate things?
Yeah, talk about a logistical nightmare for businesses. So the government's amicus brief was like a big amen to Parker Drilling's argument, keep it federal. But let's not forget, the Supreme Court justices had their own questions and concerns throughout this whole process. What were they most focused on?
They really grilled both sides, which is their job, of course. But a big thing that kept coming up was, okay, what do applicable and inconsistent actually mean in OCSLA? Like, how should we interpret those words in this specific situation? They wanted to be sure the Ninth Circuit hadn't just treated the OCS like it was just another piece of California.
Right, because it's not. It's this unique space with its own legal status.
Exactly. And another hot topic was the Secretary of the Interior's power. They really dug into whether the Secretary could make regulations that would overrule California's wage and hour laws on the OCS, even if OCSLA doesn't explicitly say they can do that for labor issues.
So they were really trying to figure out the boundaries of the Secretary's authority. Did they get into those practical considerations that Newton's side was raising?
They absolutely did. The justices definitely understood that workers move back and forth between state and federal waters all the time. Yeah. And they asked some tough questions about whether different rules could lead to confusion, unfairness, you name it.
It sounds like they were grappling with a big picture, too. Like, how does state law work in federal enclaves in general, not just this one case?
Oh, yeah. They were thinking about the precedent this could set. They wanted to know if there is any solid legal support for the Ninth Circuit's way of doing things. Justice Breyer even brought up an interesting point. He was hesitant to overturn a bunch of decisions from the courts of appeals that had all basically agreed on this gap-filling approach, which, is more in line with what Newton was arguing.
Makes you realize how much weight those lower court decisions carry.
Huge weight. But in the end, the Supreme Court went with Parker drilling, like we talked about earlier. So for our 10th chair perspective, let's get a little creative. Imagine there's one more justice on the court, and they get to offer their own take on this case. What might their reasoning be?
I love this part. Let's put on our Supreme Court robes.
Okay, so picture this. You're the 10th justice. You're really thinking about the core nature of the OCS. It's a federal domain, first and foremost. And while you respect that tradition of using state law to fill gaps where there's no federal law, in this case, we've got the FLSA, it's a pretty comprehensive federal law on wages and hours. So letting state law in here could actually create the very inconsistencies the FLSA is trying to prevent. It could turn into a patchwork of different rules, and that just doesn't seem right for a federal zone. Plus, remember that sleeping time example? That's a perfect illustration of how things could get messy. So you, the 10th justice, would probably lean towards upholding federal law. It just fits with the big picture here.
A compelling argument. You really highlighted that tension between state and federal power, and how in this specific situation, federal law seems like the logical choice.
It's all about striking that balance.
Yeah.
Well, there you have it. That was Parker Drilling Management Services v. Newton in a nutshell. We've covered the main arguments, the Supreme Court's decision, and even put ourselves in the shoes of a Supreme Court justice.
Hopefully everyone listening now has a much clearer picture of how this all played out and what it means for workers and businesses on the OCS.
It's a great example of how federalism works or sometimes doesn't work in practice. We encourage you all to think about the implications of this decision. What stood out to you the most? Does this raise any new questions about how power is shared between the federal government and the states? This deep dive is really just the beginning of the conversation.
And that's a wrap on another episode. Thanks for joining us, everyone.